Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 63rd lecture series, and we have gathered here to discuss about a very important leading case decided by 9 judges bench. The name of the case is Minerals Area Development Authority. I repeat, Mineral Area Development Authority versus Steel Authority of India. This is reported in 2024 volume 10 SEC Supreme Court cases, page number 1. So before dealing with this topic, it is our regular practice that we recite the preamble of the Constitution of India as our prayer. There is a reason for reciting preamble on every session, dear friends. One is firstly paying tribute to our founding fathers and mothers, that what was their vision about our nation. But those founding fathers, they are not living as of now physically, but spiritually their vision is still to be carried out by all of us. It is reminding oneself that you have a duty towards this nation. Being a citizen of this country, in addition to that, you are the lawyer practicing the apex court of India. So therefore, more responsibilities comes to you. So therefore, dear friends, it is our duty to remember the vision of our founding fathers and how to carry their vision in our daily life. So we have to imbibe those qualities, the key features of the Constitution of India that is enshrined in the preamble. That is why we say preamble our unity, preamble our dignity, preamble our sentiment, preamble our commitment, preamble our health, preamble our breath, preamble our soul, preamble our goal. With this thought, with this note, let us recite the preamble together, dear friends. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now, the most important leading case. It is found as serial number 82 in the AOR examination leading cases are concerned. Why it is kept in the leading case? What is the speciality in this case? It is already discussed. This leading case was already discussed both in our lecture number 60 and 61. 61 and 62. Now let me give a brief introduction about this case, and then we will go ahead with the judgment. This is decided by 9 judges bench. When it is decided by 9 judges bench itself, the quorum itself will indicate how important the subject is all about. So 9 judges, what is the ratio decidenting? What is the ratio? What is the majority? What is the minority view? Majority view, that was decided by 8 judges bench. Majority is 8 judges has concurred and authored by Dr. D.Y. Chandrachud, my Lord, Honorable Chief Justice Deedan, and then sole dissenting judgment, Ladyship, Honorable Justice B.V. Nagaratnaji. So majority 8 judges on one side and sole dissenting judgment by Ladyship. So what is the case is all about, and what are the relevant constitutional provisions involved in this case? The case involved, this case has come to the 9 judges bench, how it has traveled. There was a case decided by the Supreme Court comprising of 7 judges bench. State of India Cements Limited versus State of Tamil Nadu case. In that case, the Honorable Supreme Court has held royalty is a tax. Royalty is a tax. And state legislatures has no legislative competence to levy tax. But that was combination of 7 judges bench. Subsequently, State of West Bengal versus Kesoram, a 5 judges bench, have clarified these 7 judges bench, that is India Cements Limited. Clarifying what? 5 judges bench have held, by reading the entire judgment of India Cements Limited, it appears to be royalty is not a tax. But there are some inadvertent error had occurred. Therefore, India Cements have held that royalty is a tax. So 5 judges clarified what was the judgment given in India Cements Limited. The consequence of Kesoram judgment is that state legislature has power to levy tax. That is the consequence of Kesoram. Therefore, they are empowering the state government. Yes, being a state government, you have power to levy tax from the companies who extract mineral from your land. So, by virtue of that judgment, the state of Rajasthan, state of UP, state of Bihar, they have started imposing living tax like health cess, environmental cess on the companies. And there were some amendments in the Bihar Act related to the mines and minerals. That was challenged before the High Court of Patna. Patna High Court has held that it is violative of Constitution bench judgment, that is India Cements. State has no power to levy tax. So therefore, they have relied upon India Cements and they have said you cannot, state government cannot levy tax. So that matter went before the Supreme Court. And the correctness of India Cements is being tested. It cannot be decided by 5 judges or 3 judges because the combination of India Cements was 7 judges bench. Therefore, 9 judges bench was constituted to test the correctness of India Cements Limited, meaning thereby whether state government has power to levy tax. That is one of the issues involved before the Constitution bench judgment. Secondly, whether what is the difference between royalty and tax. We should understand what is royalty, what is tax. Then we can compare whether royalty is a tax or royalty is not a tax. So these were the many issues involved before the Constitution bench judgment. So now the constitutional relevant provisions are, please note down dear friends, Article 246. I am going to rely upon Article 246 and list 2. There are few provisions are there, please note down. Article 246. which deals with subject matter of laws made by parliament and by the legislatures of states. Meaning thereby, distribution of legislative powers to the parliament, to the state. There are three lists that you will find it in 7th schedule of the Constitution of India. Union list, which empowers the parliament to enact law on the entries on the subject matters provided under the union list. List 2, state list, which empowers the state government to enact a law on those subject matters provided under the state list. List 3, concurrent list. There are certain subject matters where both parliament as well as the state legislature has enacted a law on those subject matters provided under the concurrent list. It empowers both the parliament as well as the state legislatures. But when two laws enacted by parliament as well as by the state legislatures on the same subject matter, if there are repugnant provisions, if there are contradictions, then which will prevail? Which law will prevail? Parliament law will prevail over the central law, will prevail over the state law. That is the settled principle of law. Now, I said Article 246. Now, there are two lists, dear friends. Please note down. List 1, that is deals with union list. Entry 54. List 1, entry 54. Because everything, entire aspect of this leading case is revolving around these entries, dear friends. Therefore, please note down. List 1, entry 54, which deals with regulation of mines and mineral development to the extent to which such regulation and development under the control of the union is declared by parliament by law to be expedient in the public interest. So, the meaning thereby, parliament can enact a law with respect to this subject, entry 54, to regulate mines and mineral development to the extent to which such regulation and development under the control of the union is declared by the parliament by law to be expedient in the public interest. This is list 1, entry 54. Now, let us move on to list 2. Entry 50. List 2 means state list. Entry 50. Taxes on mineral rights subject to any limitations imposed by parliament by law relating to mineral development. Dear friends, you have to listen very carefully here. Taxes, it is under the state legislature. State government has power to levy tax. That is what they are saying. Taxes on mineral rights. But it is not absolute. Subject to any limitations imposed by parliament by law relating to mineral development. So, state government has power to levy tax on mineral rights. That is number 1. We can split into 2 elements or even 3 elements. One is state government has power to levy tax on mineral rights. Number 1. Number 2, subject to any limitations imposed by parliament. Number 2 is subject to any limitations imposed by parliament. Number 3, how they will impose conditions, how the parliament will impose conditions or restrictions on the state legislature. By third ingredient is by law relating to mineral development. So, this is how we have to read, dear friends. we can split into three ingredients for our better understanding. By law relating to mineral development. This is entry 50. So now the Bihar, state of Bihar has enacted a law based on this. It was challenged by saying that it is violative of India cements because the state government cannot levy tax. That is how the matter comes to the 9 judges bench. Now what we need to see is what is the majority decision and what is the minority decision, right? Now let me take you to the majority view. Dear friends, for advocate on record examination is concerned, that you can, though it is running more than 300 pages, but what you need to write is the essence, the core subject matter, the majority views. So therefore that you will find it at page 180 of 2024 volume 10 SEC. At page 180 you will find the majority view. 8 judges has concurred. Let us read one by one. In view of the above discussion, we answer the questions formulated in the reference in terms of the following conclusions. Number 1, whether royalty is a tax or not. That was the question. The answer is, the majority has held royalty is not a tax. Please note down. Royalty is not a tax. Then what is royalty? If it is not a tax, then what is royalty? Royalty is a contractual consideration. Is a contractual consideration paid by the mining lessee to the lessor for enjoyment of mineral rights. The liability to pay royalty arises out of the contractual conditions of the mining lease. The payment made to the government cannot be deemed to be a tax. The payment made to the government cannot be deemed to be a tax merely because the statute provides for the recovery as arrears. What does it mean, dear friends? Let us understand this. On the last occasion also I said, to understand the royalty, let us understand the landlord-tenant relationship. See, tenant is residing in a landlord's premises. Landlord is letting out his premise for the enjoyment of the tenant. But what is the consideration that landlord is getting by letting his premises to the tenant? The consideration is he receives the advance amount also in lump sum. Number 2, he receives every month rent. That is what the tenant is supposed to pay to the landlord. If the tenant fails to make a rent to the landlord, then landlord may initiate eviction petition against the tenant for non-payment of arrears of rent. Likewise, let us come to this royalty. You consider any state, for example, state of Tamil Nadu. If some company wants to extract minerals from a particular land, they cannot go with their laborers and enter the land and then they cannot start extracting the minerals, because the trustee is a state. If you look at doctrine of public trust doctrine, all the natural resources, air, water and all other natural resources are vested with the state government. It is an obligation, it is a duty on part of the state to protect the natural resources as a trustee, right? So when the state government is a trustee for the natural resources, nobody can enter into those premises without the permission of the government, without the permission of the state. So therefore, a company applies to the state of Tamil Nadu that we find there are minerals over there. We are working in minerals, extraction of minerals. So let us enter into a lease agreement. So they enter into a lease agreement where both the state as well as the company agree to certain terms and conditions. So state allows the company to extract minerals. But what is the benefit that state will get out of it? The state will get royalty. In terms of money, as you say, rent in tenant-landlord relationship, here the leaseholder and the lessee, he pays a royalty, he pays some amount to the state government. So revenue is generated for the state. So that revenue is used for the public purpose. So once revenue is generated, this revenue royalty arises out of contractual relationship, because it's a contract. Lease agreement is entered between the company and the state through a contractual relationship. So royalty arises out of contractual relationship, therefore it is not a tax. Then what is tax? Tax is a state's sovereign power exercised. Tax is levied by an authority of law. And that authority of law, that power is the sovereign power being exercised by the state. Tax, when a state government is levying a tax, it arises out of provisions mentioned in the statute, not through a contract. So that is the major difference between a royalty and a tax. For example, if royalty is not paid by the lessee, how the state government will recover? The mode of recovery is how the state government recover the tax. The same method is applied to the royalty also. You cannot, the recovery mode is the same as that of the recovery of arrears. It doesn't mean that royalty will become a tax. So this is what the first point delivered by our honorable judges. I read once again, dear friends. Royalty is not a tax. Royalty is a contractual consideration paid by the mining lessee to the lessor for enjoyment of mineral rights. The liability to pay royalty arises out of the contractual conditions of the mining lease. The payment made to the government cannot be deemed to be a tax merely because the statute provides for the recovery as arrears. This is the first majority opinion. The second aspect is list 2, entry 50. So we have seen list 2, entry 50 just now, dear friends, where the state has the power to levy tax on mineral rights subject to the conditions, subject to the limitations imposed by the parliament by law. So list 2, entry 50 does not constitute an exception to the position of law laid down in N.P.V. Sundararamayya. There was a decision in N.P.V. Sundararamayya in which here the majority opinion is list 2, entry 50 does not constitute an exception to the position of law laid down in N.P.V. Sundararamayya. The legislative power to tax mineral rights vests with the state legislatures. This is very important, dear friends. The legislative power to tax mineral rights is vested with the state government, meaning thereby state government has legislative competence to levy tax. Parliament does not have. Each word is very, very important for the simple reason to arrive at this conclusion. Lordships have discussed nearly 50 to 60 pages. So if you are reading one paragraph, it is equivalent to that you have read 60 pages. So therefore, that much importance it is to be given to these paragraphs, dear friends. Don't take it lightly or don't read it in depth. The legislative power to tax mineral rights vests with the state legislature. Parliament does not have legislative competence to tax mineral rights under list 1 entry 54. Just now we read list 1 entry 54, but parliament cannot levy tax under list 1 entry 54. Why parliament has no power? Reason is it being a general entry. This is the reason. Being a general entry. Since the power to tax mineral rights is enumerated in list 2 entry 50, parliament cannot use its residuary powers with respect to that subject matter. When there is a specific entry which is exclusively empowers the state government to levy tax, the general entry which gives power to the parliament, they cannot exercise their residuary power to levy tax. So parliament has no competence under list 1 entry 54, whereas list 2 entry 50, state government has got legislative competence. Number 3, list 2 entry 50, list 2 entry 50 envisages that parliament can impose any limitations on the legislative field created by that entry under a law relating to mineral development. The MMDR Act as it stands has not imposed any limitations as envisaged in list 2 entry 50. See, let us look into it, dear friends. What they are saying is, under list 2 entry 50, parliament can impose any limitations by authority of law. So what was the law enacted by the parliament? Mines and Minerals Development and Regulation Act 1957 was enacted, right? So the meaning thereby parliament has enacted a law also. So whether that law prescribes any limitations on the state government from levying tax, that is the question. The answer is, what they are saying is, MMDR Act, in short, Mines and Minerals Development and Regulation Act, as it stands, has not imposed any limitations as envisaged in list 2 entry 50. So though there is a law enacted by the parliament, Mines and Minerals Development and Regulation Act, but it does not impose any limitations, right? Meaning thereby state legislature has legislative competence. By enactment of this MMDR Act does not impose any limitations on the state power from levying tax. Now, the next point is the scope of the expression any limitations under list 2 entry 50. I want to pause here for a moment, dear friends. Constitution of India, as you all know, adopted in the year 1949 and enforced in the year 1950, and this constitution provisions, what was enacted by our forefathers, still continuing, and due to change in time, parliament makes certain amendments to suit the what is necessary. But who is the final interpreter of the constitution provisions? The Supreme Court of India. The Supreme Court of India alone can decide what is the constitution say. What the honorable Supreme Court judges in their wisdom, rich experience, that they say this is what the constitution is, that is what the authority of law is. The classic example is under list 2 entry 50, the term limitation is there. Any limitation imposed by parliament by law. What is that meaning of limitation? What is the meaning of limitation? That was the question before this honorable bench judges. They have said we have to give wide interpretation to any limitation. So what is that limitation means? Limitation includes, this is where the interpretation of the judges comes in, dear friends. Limitations includes restrictions. Limitations includes restrictions, conditions, principles, and it may go to the extent of prohibition. Who says all this? Constitution does not say. The judges, honorable judges, in their wisdom, they interpret the term limitation and they say this is what the limitation means. So you can bring restrictions under limitation, principles, conditions, prohibitions under limitations. The classic example is the right to life and personal liberty under Article 21. How it is evolved, how the rights are given to the citizens of this country by our honorable judges. You have a right to life, but right to life does not mean mere animal existence. It requires a life with dignity. And there are few questions arose. Right to freedom of speech and expression includes press also. Right to speech includes right to silence also. So whether right to life includes right to die? They said no, you don't have right to die. Whether euthanasia, that is subject to certain conditions. So lordships has given, by interpreting, they have given wide powers and rights to the citizens of this country, because the entire system is existing for we the people of India. Why? We the people of India has given constitution to ourselves, and we have promised to ourselves we secure to all its citizens justice, liberty, equality, fraternity. It is our constitution. So every Indian to cherish this holy constitution. This is the holy book for Indians are concerned, dear friends. Now the limitations, how they have interpreted the term limitation we have seen. I repeat, the scope of the expression any limitations under list 2 entry 50 is wide enough to include the imposition of restrictions, conditions, principles as well as prohibition. So they have given wide coverage to the limitations. Next point is the state legislatures have legislative competence under Article 246 read with list 2 entry 49 to tax lands which comprise of mines and quarries. Mineral bearing land falls within the description of lands under list 2 entry 49. There is one more entry that I need to bring it to your kind notice. List 2 entry 49. List 2 entry 49. Taxes on lands and buildings. That's all. It deals with taxes on lands and buildings. Now, what is the meaning of land? That comes for consideration before this honorable court. Whether land includes minerals, land bearing minerals also or not. For which I will deal by saying that the state legislatures have legislative competence under Article 246 read with list 2 entry 49 to tax lands which comprise of mines and quarries. So land means what is mentioned under 49 entry 49, taxes on lands that includes a land which comprise of mines and quarries. Mineral bearing land falls within the description of lands under list 2 entry 49. Where do you get this? Mineral bearing land falls under the scope of land. It is an interpretation of the Honorable Supreme Court. Next, the sixth point. The yield of mineral bearing land in terms of the quantity of mineral produced or the royalty can be used as a measure of tax, can be used as a measure to tax the land under list 2 entry 49. So what they are saying is, when a state government wants to levy a tax, what is the yardstick? How much they can levy tax? They can consider either the royalty, what is being paid, or what is the yield of mineral bearing land. So to this extent, one particular judgment, the decision in Goodrick, is clarified to this extent. By interpreting this, they have clarified a judgment called Goodrick. Next, 7th point. List 2, entries 49 and 50 deals with distinct subject matters. List 2, entry 49, list 2, entry 50 both deal with distinct subject matters and operate in different fields. This is the interpretation of the Honorable Supreme Court. Mineral value or mineral produce can be used as a measure to impose tax on lands under list 2 entry 49. So they can consider what is the royalty, what is the yield of mineral land, mineral bearing land. They can impose tax on lands under list 2 entry 49. The limitations, the next point is, so these are all the crucial points where the examiner will expect our AOR people to write. The limitations imposed by Parliament in law relating to mineral development with respect to list 2 entry 50 do not operate on list 2 entry 49 because there is no specific stipulation under the constitution to that effect. So the question here is, list 2 entry 50, they specifically say subject to the limitations imposed by the Parliament. With the same power given to the Parliament to impose limitations, does it apply to entry 49 also or not? The answer is no. Because it says, entry 49 says, list 2 entry 49, taxes on lands and buildings only. But as far as 50 is concerned, taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. So you don't apply this any limitations imposed by Parliament to entry 49. Entry 49 does not say so. But how the matter was argued is, there is a principle of constitutional silence, or when there is a legislative vacuum, it calls for interpretation. Because right to privacy was never a fundamental right. But in Justice Puttaswamy case, they have held right to privacy is a natural right. It's a basic human right. So they read into Article 21. So when there is a vacuum, when there is no express provision, but still lordships, by interpreting with context of the facts and circumstances, they declare a law. But here what they have held is, we cannot bring the limitations by Parliament with reference to list 2 entry 49, what was found specifically in list 2 entry 50, for the simple reason that it is not found there. So what is not expressly mentioned, you cannot, this is not a fit case to interpret that it applies to 49 also, we will not interpret. Though the principle of constitutional silence and legislative vacuum was discussed, but they said this is not a fit case to interpret and apply Parliament's limitation power to entry 49. The 9th point, dear friends, the decisions. Now, what is the effect of all this discussion? Ultimately, which judgment is under question, which judgment under consideration before the 9 judges bench. The decision in India Cement, not only India Cement, subsequent judgments also, India Cement, Orissa Cement, Federation of Mining Associations of Rajasthan, Mahalakshmi Fabric Mills, Saurashtra Cement, Mahanadi Coal Fields, and P. Kannadasan. These are all the judgments, dear friends, are overruled to the extent of the observations made in the present case. The registry, so India Cement is overruled. That means royalty is not a tax. India Cements held royalty is a tax. That is incorrect. See, this is overruled. Why it is overruled? Because royalty is not a tax. They have distinguished what is royalty, what is tax. Royalty flows from the contract, but tax flows from the statute. Very good. So therefore, the registry is directed to take administrative directions from the Honorable the Chief Justice of India for placing the matters before an appropriate bench. Thank you so much, dear friends, for your patience hearing. This is the majority view. Thank you so much.